We need to understand that discrimination against women and girls is one of the most difficult and most intractable of all human rights problems. This is the same, I think, for pretty much every country in the world. We can look at the national legal and policy framework around women's rights as the architecture, perhaps the foundation of what is required in a particular country. It's very important that the National Human Rights Institution understands that legal and policy framework thoroughly.
Our job task is to review the law, criminal law and another civil law. We are looking which article is discriminate women, and also to compare with Human Rights Convention, which is government side.
We have given a lot of attention on the development of a draft law for the protection of girls and women victims of gender-based violence. We also review all the legislation and see how the discrimination on the basis of sex is affecting women.
Many countries, states, have sought to eliminate discrimination in the content of law, but implementation has been not at the level that is required to actually do that, empowerment of women's equality. And so national rights institutions, because they are monitors, because they have the investigative function, because they can have the attention of parliaments, for example, are an oversight mechanism.
But nonetheless, you cannot simply, shrug off the responsibilities and put off your hand and say, well, until the system changes, there's nothing doing. What probably, I think, would be of utmost importance and a fundamental, I think, change that will be brought about is the initiative that we have taken very recently, and that is coming up with a draft anti-discrimination legislation. And there, discrimination on the basis of sex or gender is something which is a punishable offense. So we are quite at an advanced stage.
In 2012 December, there is a rape of a girl. It created a lot of furore in India, especially in Delhi. We held a national conference to discuss this issue, and we suggested some recommendations, and it resulted in the amendment of Indian Penal Code, Evidence Act, and also the Criminal Procedure Code. There are series of enactments to protect the rights of women, and also the trafficking of women, children. It is not only because of the effort of NHRC alone. The people wanted a serious amendment to law. There was an urge by the people to have a change in the law.
But national institutions have the ability, through their work, to be able to identify where the needs are and where the opportunities arise. So, for example, in many countries, it's women who are in marginalised groups who will be most vulnerable to having their human rights violated. So, for example, we can be looking at migrant communities. These young women, girls, are another group that can be identified as particularly vulnerable. And there are particular areas of law that require particular attention and specific attention from national human rights institutions. So, for example, in many countries, family law, property law, these are areas that can contain within them either explicit or perhaps hidden discrimination against women.
National human rights institutions have a particular provision. Most of them have a particular provision in which they can engage with the courts as a so-called friend of the court or amicus curiae. And that allows institutions to be invited to the court to present a human rights submission. That in turn can provide a really important educative role to the judiciary, to judges, and it has often had a major impact. for example, in the Maldives.
A couple of years ago, there was a very unfortunate incident of a girl who was sexually abused by her stepfather since she was 9. Well, it actually started with the girl giving birth and the mother and the stepfather colluding to kill the baby. During the investigation, they somehow asked the girl about the incident of her stepfather abusing her, and apparently she admitted that she had had sex with another man apart from her stepfather. When the case was heard before a judge, he asked her whether she had fornicated, and she said yes, she did it. And immediately she was sentenced to be flogged. And the case got a lot of media attention, both local and foreign. And we as a Human Rights Commission, we needed to intervene, be a friend of the court, to change this so that this does not happen to anyone else. I was actually given the opportunity to speak on her behalf at the High Court, and I appealed to the judges that this is enough. Now, please just make this right. And a few weeks later, they came out with the verdict that the juvenile court ruling should be overturned, and she was acquitted. This case was a success, yes. But what happened afterwards? Did she get redress? Did she get compensation from the government? Did she get her respect back within the society? No. And that's what worries me today.